Hey everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors. And this week's contract tip has to do with you as a licensed real estate agent buying or selling real property for yourself. In other words, how it is couched in license law is agent as principal. And there are several license laws to which you must adhere, as well as any of your own broker's policies. But basically, the license law says that now that you have a license, a real estate license issued to you by the state of Georgia, anything that you do regarding real property, buying, selling, renting, landlording, exchanging on a 1031 tax-free exchange, anything that you do with real property now must be under the auspices basically of your broker. So basically the question is, why do I have to tell my broker that I am marketing a property that I own if I'm not paying a commission? Well, it doesn't matter. The license law does not allow the licensee to draw a distinction between themselves performing real estate activities for others, for the public, or for themselves. And in order to protect the public, it requires the licensee to comply with the license law provisions, whether acting as agent or principal. What the license law actually reads, there are two tenets of license law that apply to this. One is the GREC rule 520-1-.11 number 1. And basically that says you cannot do anything without notifying your broker in writing and gaining their consent. And then the OCGA law, the annotated official code Georgia annotated law 43-40-29C states, and I quote, in order to protect the public, it requires a licensee to comply with its provision, whether acting as an agent or as a principal. Brokers are required to review all of their affiliated licensees for compliance with the law, whether that activity is for you as an agent acting for somebody else or as a principal and the agent acting for yourself. So basically what that means is you cannot practice real estate outside of your firm, in essence. Now again, some of you may have some of your real estate firms might have different actual policies regarding commission and advertising and marketing, so forth and so on. But you as a licensee, you must adhere and comply with all real estate media advertising laws too. Number one, must be in the name of the broker, must not be misleading, so forth and so on. All the specific license laws pertaining to marketing and advertising. Additionally, when you are the principal, when you are the buyer, seller, landlord, tenant, any of those participants within a transaction, you must disclose that you are a licensed agent in the state of Georgia. You do that whether you put in words, principal, seller, buyer is licensed principal in the state of Georgia, putting your license number, so forth and so on, but that must be disclosed in all of your marketing and advertising. So the issue comes into a couple of things that we find brokerage-wise, brokers normally have to have conversations with licensees about. And a couple of the issues. The first issue has to do with agents who are investing in real estate for themselves. So especially if you were an investor before you went and got your real estate license, the laws are completely different. Now that you have a real estate license, you are held to license laws and must adhere to them. So if you are a licensed agent and you go and buy and sell property for yourself as an investment strategy, you cannot do that outside of the brokerage. It must be done within the brokerage. You have to do it, as I mentioned, just like you would help any member of the public buy or sell property. So if most brokerages also require that you sign a listing agreement if you are listing a property and a buyer brokerage agreement if you're buying a property. because although you are the agent of the broker representing yourself as the buyer or the seller, those brokerage agreements are with whom? Yes, they're with the broker, they're with the company. So you have to sign those documents, and license law says that if the party is engaging in a client relationship with the broker, then you must sign a listing agreement if it's a seller client, and you must sign a buyer brokerage agreement if it is a buyer client. So license law, you have to sign those anyway. And regarding what fees your broker may or may not charge, now the fee issue, that is completely up to your broker and whatever's in your independent contractor agreement or in your policy manual, whatever relationship, whatever is written out and whatever policies your broker has on that. But regardless of what your broker's policies are on payment, those contracts must be turned into the broker, whether manually or electronically, and they must go through a compliance review, a compliance check, and especially where you are handling someone else's money. In other words, if you are handling an earnest money deposit or if you are handling a security deposit, those must go through the broker. Those must be deposited into a trust account that is registered with GREC. Now, the broker's trust account is already registered with GREC. You as an agent, in certain circumstances, license law allows you to hold a trust account in your own name, but that trust account still must be registered with GREC. And the only way it can be registered with GREC is if your broker registers it with GREC. So again, that is a specific firm's policy. Even though license law allows you as an agent to have a trust account, that is a firm's policy whether that company allows their agents to have their own trust accounts or not. So that leads me to the second issue. So again, the first issue is if you are an investor or if you are investing in real property for yourself, again, those contracts, those everything about that, those listings and those purchases must run through your brokerage, must go through a compliance check. The other issue has to do with property management. Now, every firm has a policy if they do or do not allow their agents to practice property management for the public. But what about you? When you own a property that has tenants in it and you're managing that property that you own, what does license law say about that? Well, license law states that let me just read it to you. Basically, all trust money must be placed in a trust account of the broker holding the licensee if you do not own that property 100%. In other words, you must be 100% on title to that property. If that property is held by an LLC or any other corporate entity, you must be the sole member of that LLC. If that is the case, and if your broker allows it, then a security deposit for those rental properties may be held in your own trust account, again, if your broker allows it and if your broker has registered that trust account with GREC. If your broker does not allow you as an agent to have your own trust account and that's not registered by GREC, then even if you own the property 100% or are 100% sole member of the LLC that owns the property, the security deposit must be held in your broker's trust account, or you can hire a property management firm. If the broker may give the licensee, again, to, for you to have your own trust account, check with your broker. But if you don't own it 100%, even if your broker is giving you permission, that's not allowed by license law. That is illegal. So potentially what happens? Well, all the same rules or good business practices for leases applies. And the issue is you can manage your own property that you own outside of the broker. Well, the broker has to have knowledge and give you permission. But that trust money, that security deposit must be held by the broker. And in order for it to be released, the broker is going to hold those release issues just like they would if you weren't the principal in the deal, if you weren't the landlord in the deal. So before you place that trust money into the that security deposit into the trust account of your broker, you must have a copy of the lease fully executed and a fully executed move-in inspection form. That way, when the tenant moves out and vacates, there should be a fully executed move-out form so that the broker still, for compliance-wise, the broker can't release those funds without following the proper procedures and laws based on how to release any type of trust money, especially security deposits having to do with leases, move-out inspection forms, and everything else in the lease. So again, bottom line, if you are basically three issues. If you are an agent and you invest in property for yourself, whether to hold it and rent it out or whether to flip it or whether to sell it, but as an investment, all those transactions must run through your broker. They must go through a compliance check by license law. The compensation for those deals, that's an issue to discuss with your broker. That's number one. Number two, if you are a licensee and you are purchasing a house as a residence or you are selling a house as selling your own personal residence, those issues, those contracts too, and those listings must go through your broker for a compliance check regarding compensation issues. Again, check with your broker, with your independent contractor agreement and the policies of your own firm. But you cannot practice real estate outside of your brokerage without your broker's consent by virtue of you now having a real estate license issued to you by the state. And then the third issue is property management for property that you own. Different laws fall into place whether you own it 100% or not 100%. And then again, your brokers, your firm's policies and procedures fall into place. Check with your broker on that. One more thing. If you are a licensed real estate agent, but your license is inactive, you still must comply with the license laws for real estate. In other words, obviously you're not going to have a broker to market and advertise your property in the name of, but you must disclose on all of your marketing, including signs, flyers, anything like that, listings, anything online, you must disclose that you are indeed a licensed agent in this state. We're here in Georgia, so in the state of Georgia, even if that license is inactive. So hope this video contract tip helped you out. Thank you so much for watching. Again, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.